Our debate, and indeed the debate today, is about the legal consequences of the decision by the South African government to allow the President of Sudan, who has been indicted by the ICC for war crimes, crimes against humanity and genocide, into the country, and in spite of a court order to allow him to leave the country again. This may bring a number of legal obligations into play, and that's in essence what our debate is about. On the global level, our obligations under the UN Charter, the ICC Statute, and possibly the Genocide Convention. On the regional level, the Constitutive Act of the African Union, and possibly the African Charter on Human People's Rights. And on the domestic level, our obligations under the South African Constitution and the ICC Act of 2002. Our main concern today is the nature of these legal obligations. Did they require a different approach from the government, or are they to a greater or lesser extent in conflict, allowing the government the space to take its own decisions? Much of the debate so far has been in sound bites, but I think today Johan and Dira will develop the finer nuances of the possible different approaches to this question. And I think what we are trying to do then is to establish really behind what is said in the news lines, to what extent on the legal basis can one say there's a clear legal obligation, or to what extent is it perhaps not as clear as it seems.
There are three reasons why the South African government was compelled to arrest President Al-Bashir. First of all, because there was an order issued by the Security Council of the United Nations, acting under its so-called Chapter 7 powers. Decisions of the Security Council under Chapter 7 of the Charter of the United Nations are obligatory. States of the world are compelled to execute them. And so the fact that the Security Council instructed the states of the world to cooperate with the International Criminal Court in bringing Al-Bashir to justice means that we are compelled to do so. The second reason is because South Africa is a state party to the statute of the International Criminal Court. The functioning of the International Criminal Court is to a large extent dependent upon state cooperation. The provisions in the ICC statute that deals with state cooperation falls into two categories. Some are conditional, one is unconditional. The duty to execute a warrant of arrest and to surrender a suspect for trial to the ICC is an absolute duty not subject to any reservations. So South Africa is compelled to execute the warrant of arrest. There's no exception to the rule. The third reason is because South African law provides that South Africa must comply.
Let me now begin with my views on the matter. And my views on the matter is that it's really complicated and nuanced. I don't take a position one way or the other. What I do say is the following. Anyone who says to you, it's simple, it's straightforward, there's an obligation, is wrong. It's not simple, and it's not straightforward, and it's complicated. There is a conflict of obligation both at the international level and at the domestic level. That's essentially my point, right? That conflict has to be resolved. How it is resolved, I don't know. But we have to admit, if we're really being honest with ourselves, forget that he's the devil. This is not about Al-Bashir. This is about the law and what the law means, right? It's not about Al-Bashir. It's about what the law means. And if we are really honest and faithful about what the law means, we will accept that there is a conflict of obligation.